So, good afternoon, everyone. My name is Ine van Zeeland, and I have the pleasure of presenting to you a panel today on behalf of the Brussels organization of CPDP, or the organization behind it, which is called Privacy Hub. This panel will be conducted in English, and that is my fault because my Brazilian Portuguese is not very good at all. So the panel will be conducted in English, but afterwards you are free to ask your questions in your own language, as long as it's Portuguese, Spanish, or English. I'm going to give each of these speakers about 8 to 10 minutes to talk about their topic. I'm very pleased with this very good panel that we have here today with very high-level expertise on the topic that we will be talking about, which is the impact of the EU Artificial Intelligence Act on AI policy and governance on this side of the Atlantic. And specifically, we will be talking about the role of supervisory authorities and whether it will be necessary to have specific AI authorities, or it's also possible to look at authorities that already exist. And I'm going to start by giving the word to Philippe Medon. You have a master and a doctor in civil law, and you're here working as a professor in civil law at FGV. You're a lawyer and a researcher, and also a poet, I heard. An author of the book Artificial Intelligence and Civil Responsibility, Autonomy, Risks, and Solidarity. And you have integrated a team of legal scholars who have worked on the AI bill for Brazil. So I'm going to give you the word. Please welcome.
Thank you so much. Before anything, I would just would like to be mindful of my time, of your time as well. Thank you, first of all, the Privacy Salon for this amazing invitation to be here. It's a huge honor to take part in such a panel with all these experts around me. And I just can't miss the opportunity to remember our dear friend, Danilo Doneda, once again, who has been remembered ever since we started this morning, but it's never too late to remember him again, and we'll be always doing that. Well, I'll try to make it as quick as possible on a AI regulation timeline in Brazil. This AI regulation in Brazil, we can't start by regulation, at least not by hard law. We have to go back and start with the Brazilian strategy on AI, the so-called EBIA. It was first introduced in 2021, but it was said that it was incapable of dealing with concrete problems of AI. It did not provide enough tools for us to deal with the concrete problems posed by AI. Therefore, this strategy is now under review. So we'll probably have an updated version of this strategy in a couple of months. That's at least what is expected. And at the same time, they started to develop in Congress different bills on AI. And that is something interesting because the bills did not specifically consider and took into consideration the work that had previously been done by the Brazilian strategy on AI. The first bill that was introduced in Congress was in the Chamber of Deputies. It was called Bill 21A20. A because it was the second version that was approved by the Chamber of Deputies. And something that is kind of shocking is that it was approved in an urgency regime. So what was the urgency to approve an AI bill back then in 2020 when it first was introduced in Congress, and it was approved in 2021? Some might claim that it is considered a principle-based approach on AI, but I wouldn't agree with that. I don't think that is a principle-based approach. It is a no regulation at all approach. It is based on general principles. It brings no clear definition of responsibilities or sanctions, and it doesn't tackle specifically the enforcement of the AI bill in Brazil. Therefore, this bill arrived at the Brazilian Federal Senate, and the Senate realized what it was clear to everybody else. The bill was incapable of coping with all the challenges posed by AI. So the Brazilian Congress decided to create a committee of jurists, of experts, which I had the honor to be part of it. And we have worked throughout the year 2022 to bring a new bill, the so-called Bill 2338, which was only introduced last year in May. But what was the core of that bill? It was, first of all, a human-centric approach. It had a human-centric approach, and Professor Doneda was one of the members of that said commission, and I clearly remember, vividly remember, he was sitting next to me when he said in the first hearing in Congress, this is a human-centric approach to AI. The second thing, it provides, just like the AI Act, a risk-based approach, but it goes beyond, because it not only brings a risk-based approach, but also brings a rights-based approach, which is something that we call here in Brazil as jabuticaba, a small kind of grapefruit that we only have in Brazil. And it's something that stands from the other bills that are being discussed abroad. But of course, that did not please everybody, especially the private sector, on the grounds that this bill provided, in their view, a lot of extreme measures that could stifle innovation. So what was argued back then is that the bill provided so much governance measures that it could stifle innovation. So what the Senate decided to do, instead of voting the bill, they have appointed a new committee. This time the committee was composed by 13 senators. And these senators were appointed last August, and they were supposed to have ended that discussion last year, but they are still postponing. Every week we say, oh, there's not gonna be there will be a vote right now, but the vote never comes. Last week, a couple of us were here in the audience as well. We were in Brasilia, and it was really expected that there was going to be a vote, but once again, it was postponed. And so far, there is no clear sign on whether it will be voted or not and when. But the main thing about this new committee is that they have proposed, the Senator Eduardo Gomes, the rapporteur, he has introduced new versions of the bill, updated versions of the bill. And these updated versions, they have carried out on the rights-based and rights-based approach, but they have changed something very important, which is the structure of the enforcement. And that is what I'd like to spend my last minutes on. The first version, as I already mentioned, the 2120, approved by the Chamber of Deputies, provided no enforcement at all. The first version of Bill 2338, which was the outcome of the Commission of Experts, it provided a model of regulation, of enforcement, focused on a single body. It would be called the so-called competent authority. This competent authority, which would be defined by the administration, the executive branch, this authority would have the power to enforce AI in Brazil. So it would be a single body. What has changed in the latest versions of the bill? They have now introduced a system of regulation. Instead of a single body, it is now a system of AI regulation and governance. So what seems clear among all this belief in this bill is that at least they have agreed on something, which is a multi-sectoral approach on the regulation and enforcement of AI. So it is expected that this ecosystem, the system of AI, which is called SIA, who will be part of this commission? Sectoral bodies. They will represent private sector, for instance. A committee and a council who will be created and who will have many members. And that's arguably the most controversial thing, the Brazilian DPA, the Brazilian Data Protection Authority, ANPD. The first thing about this solution is that there are some concerns whether it is constitutional for the Senate to appoint this authority. That is something that has already occurred when we were discussing our data protection bill, which is the fact that is the Senate competent in terms of constitutional law to appoint an organ, to create, to make the government spend money on creating something? That is something under discussion. But another point is that ANPD will be the coordination body. it will be the coordination body in charge of trying to raise dialogue among all these people who will integrate, who will take part in this ecosystem. But among all these concerns, there are some people raising questions like, will it be capable of dealing with artificial intelligence given the current structure? Because it's a small structure these days. But on the other hand, there is another very strong argument, which is, okay, if we build from scratch, it will be even harder. So should we take advantage of existing authorities, existing bodies to enforce AI, or should we create something from scratch? That's pretty much what's being at stake right now. But to close in my last minute and a half, and comparing with the AI Act, there's something that I've recently read, written by Professor Nathalie Smurra, who was even with us here a couple of weeks ago. And she said something regarding the AI Act that I think that we could apply to Brazil as well. She said, we must be careful that AI Act won't be turned into motherhood and apple pie. And what she means by that, by saying that we shouldn't turn into motherhood and apple pie, it is something that everyone agrees on the United States, but is it really effective in the real world? So is this ecosystem, all these people trying to regulate AI at the same time, capable of really enforcing and making what Roscoe Pound once said, law in action versus law in the books? Are we able of taking law from the books and taking it to action? That's pretty much what we are discussing right now. But while we still don't have an AI office, there's something we can't deny. Other agencies, such as the ANPD itself, can act on this gap. They can help bridge this gap. Because for now, since there is no office, there are certain parts where we have common grounds for the action of ANPD. So consumer law can be applied. So it's not like we have no law. We have no specific law, but that doesn't mean we have no law. But what will happen in Congress? Well, that is something that we can't predict, but hopefully we can't go back. So in terms of not going back, I'm trying to say is we can't go back to the model of Bill 2120. We have to work on the model of Bill 2338. Thank you.
Thank you very much for this overview, and thank you also for raising some of the questions about the ANPD, because we have somebody here from the ANPD. Lucas Borges, would you, from your perspective and also from your background, explain what your perspective is on the questions that were raised about supervisory authorities?
Okay, good afternoon. Thanks for the invitation. It's a pleasure to be here for the second time this day. The second and last time. I'll not be here. I'll be at CPDP tomorrow, but not in any panel. So, but I think this is very important for us at ANPD. That's why I'm here for the second time, because this is a topic that we are following close, and obvious, as Felipe just said, we are kind of the appointed authority at this moment in the bill. So this is a very important topic for us. So that's why I'm here. So I have 3 points. The question that was given to me was about the role of data protection authorities, DPAs, in AI governance. And the first thing I want to mention is something that Felipe just have said, is that existing rules apply to AI systems. So this may sound like obvious, but I think this is something that we need to discuss a little bit. And I like to start here quoting Lisa Khan. She's the Federal Trade Commission chair. So she said, although these AI tools are novel, they are not exempt from existing rules, and the FTC will vigorously enforce the existing laws. I know that the panel here, we are discussing the EU AI Act, and I'm quoting US regulator, but I made this on purpose just to emphasize that even in a country with a pro-innovation approach, which is the case of USA, it doesn't mean that any kind of rules apply, or that they are not worried about the impacts, and they don't have concerns about AI or the effects of AI in society. So from the other side, this doesn't mean that we don't need laws to deal with AI, or that there are some issues that are not properly addressed in current legislation. That's not my point here. What I want to highlight is that we can and should discuss current legislation and how it applies to AI system, especially which is the case of Brazil, when there is not a specific law to deal with AI. So this is the first thing I want to emphasize here, that existing laws, and especially data protection laws, apply to AI system. And what is more important than that is that data protection law will continue to regulate AI system, even if we don't have, in the case of Brazil, a new law, yes? So the development and implementation of AI system will have to comply with data protection law, regardless of the existence of a new specific AI regulations. And another point is that data protection law can help us achieve our goals regarding regulation, because there are many tools in data protection law that we can use to establish rules and to deal with the risks and the harms that may occur regarding AI systems. What are these tools? Data protection principles like transparency, purpose limitation, data minimization, data protection impact assessments, legal basis for data processing, and data subjects' rights. These are some rules that already exist, and that if correctly applied to AI systems, they may help us to regulate and to establish some values that these systems may follow and reduce the impact they cause in societies. So I think data protection law can help us understand how AI works and its impacts on people. It's important also, it's a very important tool to provide legal certainty to our organizations and to find a balance between justice and innovation, and also to guarantee fundamental rights. So these tools and these rules already exist, and we need to discuss how they apply, what are the best interpretation in the case of applying these rules to AI systems. Another point that I want to bring here is that there is a strong connection between AI and data protection law. That's because AI systems need a massive amount of data, and especially personal data. And AI systems that uses or that are trained with data, with personal data, they are usually classified as high risk. If you look at the EU AI Act or the Bill 2338 in Brazil, you see that many of the topics that are classified as high risk, they will involve personal data. So that's the case, for example, of facial recognition, the use of AI systems in migration issues, job selections in schools or in education. And I think that in this context, some of the most controversial issues regarding AI systems will be answered by data protection authorities. If you consider that AI systems use personal data, and that we have many tools in the data protection law that can help answer these questions, that will necessarily happen, I think. So the last point I want to bring here is that this is already happened. My time is closed, finished. So DPAs have already assumed a central role regarding AI regulation. So we're not talking here about the future, but this is already happening. It's the case of facial recognition, for example, the Clearview AI case in Europe, and also regarding generative AI. For example, the Italian DPA has issued a preliminary order against ChatGPT. In Brazil, ANPD has just issued also a preliminary order injunction against Meta. And other regulators like CNIL in France or ICO in UK, they are publishing public consultations on many topics regarding data protection law and AI systems. To finish, I would like to quote Gabriela Zanfir Fortuna of Future of Privacy Forum. She said, DPAs are already AI regulators, whether they like it or not. It really depends on them how active they are in this sense, but they have all the tools they need. So that's the message I want to bring here. I think regardless of the existence of a new law in Brazil, in the case of ANPD, we still have, we already have this role, and we are doing it. And I think that we need to advance and foster this discussion and to apply the legal tools that exist, that are present in our data protection law to answer at least some of the main questions that AI systems brings to us. Thank you.
Alberto Cedra, I saw you nod several times. Brazil is not the only Latin American country, of course, looking at AI governance. You are an associate professor at the University of Chile Law School, and you have a PhD from Georgetown University, and are currently also a member of the Committee of Experts advising the Chilean government on AI governance. What is your take on these questions?
Perfect. Hi, everybody. I'm going to skip the pleasantries. Just say thanks for the invitation to be participant of this panel. And I will skip them because I noticed that they are really tough for the time here. So I'm going into the matter that I has been requested to speak about. The primary purpose of my presentation is tell you a little bit about how is Chile dealing with this, to describe a little bit what is the institutional arrangement that we are working for related to artificial intelligence, and some reflections about that arrangement. I should start by saying that Chile, as most Latin American countries, did provide some protection to personal information way before we adopted data protection law. Like most Latin American countries, we did provide protection to personal information through constitutional provisions. In the beginning, you can see in the jurisprudence in Chile in particular that there are tons of cases, law from the 80s, in which the courts were using the right to privacy to provide protection regarding to undue possession of personal information. And that was primarily the case until 2018, when we introduced a constitutional amendment that introduced an autonomous right to control personal information. The problem with these general and abstract provisions of the Constitution is that they became really difficult to apply in practice because they are super ambiguous and abstract. And that made very evident the need to have a layer of more granular, concrete normative steps. That explained why in 1999, Chile adopted the first data protection law. At that time, it was looked at that law as a very successful experience. It did provide it was the first Latin American law providing comprehensive protection on data privacy at that time. However, the law did have a lot of shortages, being the main of them the fact that it was plagued with numerous permissive exceptions to the principle of consent. It didn't have any provision regarding to cross-border data flows, and which is more important for purpose of this conversation, it didn't have any provision regarding to an authority on the matter. During the last 6 to 7 years, the National Congress in Chile has been discussing a new data protection law that will deal with all those shortage and others. The new data protection law is meant to incorporate into the Chilean framework the recommendation of the OECD. We're talking about rules from the 80s, but also the principles and a lot of the provisions that were incorporated into the European Union GDPR. Things that you will find in this project of law that, finger crossed, should be approved over the course of the following 2 to 3 weeks and enter in force in 2 years since his official publication, in 2 years after his publication. This law introduced a new set of principles on data protection, incorporate a new set of rights for data subject, as well as new obligations for data controllers. Specific provisions on, it improves the enforcement with a regime on infringement and sanctions. It improves also institutional arrangement, and particularly why? Because it deals with international flow of information, personal data, but also it does create a competent, independent authority to deal with supervising and enforcing the data protection law. This is important because basically, as you will see, it will be in the design that we're putting together for the artificial intelligence bill. The Data Protection Authority will play a significant role. The Data Protection Authority in Chile, or agency, will be an independent authority tasked basically with supervising and enforcing the law. This is a collective organization formed by 3 members. They are chosen by agreement between the president and the Senate. That ensures somehow some political leverage, but also independence. The agency will have authority to, this is important, to interpret and oversee the compliance with the law, to issue regulation, but also will have authority to determine infractions and to impose sanctions, as well as to know about data subjects' complaints, provide technical assistance, and advise the legislative in legal modifications, and engage in international cooperation. It's a very comprehensive number of powers that this authority will have. 2 minutes, I will run them. In 2004, in May 2004, the government introduced a bill on artificial intelligence. This is not an isolated effort from the government. This is something that can be traced back to 2019, when the Chilean government, under a different administration, pushed forward for the adoption of national policy on the matter. It has been adopted at that policy in 2021. It has been renewed. A specific regulation has been adopted for the use of artificial intelligence in the administrative sector, in the administration. But we need to have a more comprehensive approach, and that comprehensive approach is the one that concretized in the bill introduced early May. The law introduced in Chile, the bill introduced in Chile, follows very closely the European Union standards. It reflects on the principles adopted by the European Union Act, principles like human supervision, transparency, explicability, and the like. It also adopts the approach of identifying a level of risks and matching the level of risk with mitigating and preventive measures in order to avoid those risks. Now, that allows to distinguish between certain systems that are forbidden and certain systems that have no significant impact or risk. The law also states a regime of infractions and monetary fines in case of infringement. And for purpose of enforcement, for purpose of institutional arrangement, it creates 2 bodies: a technical advisory board, and it builds on the top of the Data Protection Authority. The Advisory Technical Committee is a multi-stakeholder entity with representatives from the academia, civil society, government, as well as the business sector, that advise the Minister of Science and Technology on a specific regulation that is necessary to go further than the text of the law in issues to develop, promote, and implement and improve artificial intelligence systems within the country. It's the Minister of Science and Technology, basically because this has been the ministry leading these initiatives over the course of the last years. But the actual role to enforce and supervise the matter of the Artificial Intelligence Act is the Data Protection Authority in Chile. This is great because a number of challenges associated with artificial intelligence are associated with data protection. So it's fantastic in that way. It makes sense. However, on the other hand, it may overstate the relevance of personal data information in the use of artificial intelligence systems. Let me give you a couple of examples that will make the argument. In Chile, we're using a lot of artificial intelligence, and it's not only the applications that you can download in your phones. We're using artificial intelligence to manage water resources. We're using artificial intelligence for traffic control. We're using artificial intelligence for recycling industrial waste. They're limited to no use of personal information. And this raises a number of questions. Will be the Data Protection Authority prepared to deal with enforcing the law regarding to the processing of non-personal data? That's the first question. Then if you look at the powers that the authority is being provided, the Artificial Intelligence Act provides primarily, I'm summarizing here my notes, okay? Provide primarily reactive punitive measures to supervise, to know of complaints, to determine infractions, and to pass a penalty. That's it. And there is a question to be answered about what will be the powers, capacities, and resources that the Personal Data Protection Authority will allocate to provide non-reactive, more proactive roles regarding artificial intelligence, which is critical. It cannot be underestimated because a number of public governments and public servants, but also private actors, are looking for advice to know how to deal with this moving forward. And that the authority may not be the one prepared to do that. That's a challenge. I can go on and on there.
Thank you. You brought up a number of very good points indeed. The use of non-personal data, prevention of impacts rather than reactive responses, and also the independence of supervisory authority. I'm moving on to Barbara Lazarotto, who is a PhD researcher at the Law Science and Technology Studies Institute at the Vrije Universiteit in Brussels, so based in the EU. And I would love to hear, what the perspective is from the EU on the independence and also the role of data protection authorities in AI governance.
Well, thank you very much, Ine. Thank you very much for all the panelists. I am a part of the team that organized this panel. We organized this panel because we first thought about this topic as a very interesting topic, and then we organized a conference in Brussels before CPDP Brussels with FGV. We wrote this paper, a paper that will be published here at CPDP Latam proceedings, but we don't have even like answers to these questions. So probably you're thinking, yes, the Act was published last Friday. Probably you all have the answers. That probably, no, we don't. We still have the same questions that everyone posed here. They're the same challenges. So giving a little bit on the AI Act. So the AI Act was published last Friday. So now it's officially a law under the EU. As most EU regulations, it's grounded on the regulation of the internal market, but also in the protection of fundamental rights and principles of the EU as well. So this double axis is something that is always in the regulation of data protection and also digital laws in the EU. In this case, it was very complicated for the AI Act to create, to say that what you're trying to regulate. Is it just AI, but also fundamental rights? And the AI Act is based on, as the Professor Alberto said, it's a risk-based approach. So it's not as the GDPR. So it was a very complicated matter. And the AI Act said like this: we have AI institutions, they will regulate and observe how the AI Act is applied and used, but we leave to the member states to designate if it's AI authority or it's the data protection authority, for example. So certain countries, such as Spain, for example, they were the pioneers. They created this AI agency. But on the other hand, other member states, such as Italy, They designated double competence, so the data protection authority, the garante, will be competent in one part, and the cybersecurity authority will be competent in the other part. This already complicates things. So we can see that although the AI Act tried to push for a single authority, we are landing kind of the same place as Brazil did, which is not a bad thing, actually. I don't think it's a bad thing. So yesterday, the EDPB, the European Data Protection Board, issued an opinion, I guess it's an opinion, right, on this, saying that, okay, we know that there's a country that already created these designated AI authorities, such as Spain, but for the ones that didn't, please hear us out. We think that it's very important to protect fundamental rights, so we are kind of trying to make your mind that it would be interesting for us if you gave the data protection authorities the competence to regulate AI as well. So whereas the AI Act tried to push for a single, for a separated authority for the AI, the DPB is trying to go on the other way again, close to the Brazilian measures. So we don't have answers. Still, we still have some questions to make, because I agree that, for example, data protection and personal data is a very big part of AI, and I think the DPB also acknowledges that. But also we must take into consideration that the AI Act is more than that, and we have a mix of personal and non-personal data. So going back to what Professor Alberto said, we still don't have answers, and although the ship has sailed, we don't have the ship sailing very much on the sea. I think that the idea for this panel was to see if we had the Brussels effect. And I don't think we have the Brussels effect this time. I think we have a data protection effect, more or less, that is trying to see that, going back to also Purtova said, it's the law of everything. So maybe you are going back to the law of everything, which is everything that touches personal data is going to be under the data protection authority, which, since I have just 2 minutes, is just dangerous as well, because we know the data protection authorities, they don't have money, expertise to regulate and supervise this kind of technologies. They have shortage of workers. They have probably sometimes problems with independence. We had in Belgium a very big scandal with independence of data protection authorities, so it was very complicated. I was a part of an Access Now study on data protection authorities in Europe. And one of the main points that we found on this study was that they are short of staff. They're short of money. So we are, EDPB is pushing for this competence for them, although we don't see any type of changes of giving them more money and availability to enforce these rights. So I think if we push the supervision for the DPAs, probably we will have a problem also with the GDPR, because then we are putting everything in one basket. It's going to be complicated. So thank you.
Yeah, thank you very much, Barbara. You also mentioned human rights, and I think this is a good bridge to the last speaker we have, Pedro Martins, who is academic coordinator at Data Privacy Brazil, and also a specialist in profiling and personal data protection. Please give us your opinion on
Thank you.
on the topic.
Well, first, thank you for the invitation on being in this panel. It's an honor. I will also try to keep to the time. So I'll try to address this. I think this is a common issue on all those, the participations here on the interplay between data protection and AI governance. And I think there's another reason for that, because, well, trying to take a step back, when a couple years ago, maybe we were talking about data protection as something new, the GDPR and LGPD, we were very much freezing how data protection is not anymore a governance on privacy. So we are not any more tied to privacy issues, such as the knowledge of intimate information or information that is related to a person doesn't want to disclose. And then we move from this framework of privacy to a framework of data protection, where what matters is not as much as if a data reveals something intimate about someone, but rather if the processing of a data links to someone. So there is a identifiability criteria. So if it's possible to identify someone, or someone identifiable will be affected by this data processing. So there's this new framework of regulation we put forward. We put risk assessment measures, we put transparency obligations, we put accountability framework of publishing impact assessments, of registering assessments of such things as legitimate interest assessments. So a bunch of documentation that we thought as a society that was important for data processors to put forward when they are processing personal data. So we created these big arrangements to try to get a grasp on technological change. So new technologies were processing personal data in heavy amounts, and they were impacting people in the end of this process. So we put a big supervisory model that is led by a data protection authority. So even though it has a lot of obligations, there is a central authority that guides this regulation, which is a data protection authority. And when I see now the talk about AI regulation, I feel like this next step on technological regulation, which we use the same language that we created for data protection. So we created a language as society of what we consider important to get a grasp on technology, so that technology doesn't advance despite societal issues, or despite in harm of fundamental rights, or concentrating markets, or concentrating power, or creating power imbalancings, or further advancing vulnerability. So we have this common minimal framework of what this language of technological regulation is with data protection. So we have fundamental rights, we have rights of being brought by data protection regulations, we have accountability measures, we have transparency measures, and we have a data protection authority, a central figure to put forward this regulation. And now we have AI. And there is, of course, this theme that, yes, AI uses a very heavy amount of personal data, but it doesn't necessarily needs to, but this doesn't change the fact that it can even without using personal data, affect fundamental rights. So I think what we are now doing, we are now passing through a phase of abandoning identifiability as a criteria for regulation, just as the same we abandoned privacy as a criteria for regulation. So of course, there are still privacy regulations, there are still data protection regulations, but we are getting on a moment that we need to govern data in a bigger framework. And AI is like something, technology that blows this debate wide open. So we cannot, I think with AI, the thing is, it blows in our faces that we need to advance the language that we use to talk about data governance and to get a grasp on technology and to appropriate technology so that it is developed and applied in a way that promotes human rights, that promotes things that we value as a society. And this is why I think that the interplay between data protection and AI regulation is not only because AI treats personal data, process personal data, but because we have a somewhat fairly we are minimally comfortable with the language that we created for AI, for data protection regulation, and to develop new verbs and new adjectives on this language for AI regulation. So I think, so putting this framework on this very step back, how I see the enforcement systems of AI, how this theoretical thing applies on the supervisory framework. So in data protection, we have this central authority that is very important because it's a new language, so we need someone to drive forward this regulation. And now with AI, and I think as everyone here said, we have a spread of enforcement. So we have both in the EU and in Brazil, we have a very, we begin to see that it's a central authority. It may be have there are some positive effects, but there are some, because we expanded the language that we talk about, we need more people to be brought on this language. So we have sectoral regulations and actors being put forward in the CIA, the Brazilian system of enforcement, more plainly than we saw in data protection. No one says that sectoral regulations doesn't regulate data protection. Of course, it's a general law. So the financial system also, the regulator also regulates data protection because it's a general law. But we have a central figure with the Data Protection Authority. Now we are less comfortable with this central figure, and we are putting more actors in this enforcement system. So plainly, obviously the sectoral regulators are being brought on this system, but also with this spread of what we want to regulate, we begin to see also new topics that interplay with data processing. So we also see labor precarization and decent work as a topic that's beginning to be even more connected with data governance as a whole. So then we, in some versions of the law, more recent versions, we have the Ministry of Labor as an important actor in the enforcement systems in order to protect the effects on data processing on AI systems, on labor and decent work minimal standards. We see the environmental impacts of AI and its infrastructure, and then we have the Ministry of Environment as an important actor to make sure that AI developments occur in consonance with just climate justice, and that climate impact is something that should be considered on the impact of assessments of AI. And we see copyright also being something severely discussed. So basically what I'm trying to say is that as we use the foundational language for data protection, we expand it to talk about AI. We see new issues and new topics that are urgent for us to address, and AI accelerated this process a lot. And because of that, more actors are trying to be put in place in this enforcement ecosystem. I'm not quite sure if it's a good or bad thing. Like I think we all agree here, but I think at least this is where it comes from. This spread of the enforcement that the EU bill intended to be a little bit more centralized, and maybe it's not very much being applied at that. But in Brazil, this is certainly abandoned. Like this is certainly, there are already a lot of more actors wanting to participate in this ecosystem. So, and just to finalize, I think I have some time. I think this enforcement and this debate, it's incorporated differently in each of in each society and regarding socio-economic status. And I believe that in Brazil, and maybe global South as a whole, this is why we are beginning to see systemic issues such as discrimination and precarization of exploitation of labor, especially data labeling works that usually occur in the global South as issues that are related to AI. That is not something lateral or collateral to AI or parallel, but it's something completely related to AI. And because of that as well, I think the multi-sectoral approach, that is something very important in Brazil, and civic participation on governance, that is also something that I think we established on technology regulation in the last couple of years, is something that cannot be abandoned on AI regulation. So I think that's it for now. Thank you.
Yes, thank you very much for this a little bit more provocative contribution, pointing out the discourse and what has been called the proceduralization of the protection of humans in the end. I think I should have mentioned that you're also the author of a book on the free development of personality in the era of algorithmic governmentalization. So yeah, governmentality. So yeah, indeed, thank you for this focus on what is important for humans. I think we still have some time. to open the floor for questions. You can ask questions in Portuguese, Spanish, or English, whichever you prefer. Yeah, it's up to you. And there's a question over there.
Thank you all. It was very enlightening to hear so different perspectives. My name is Marcelo Malaguti. I work as a special advisor at GSI, but right now I'm talking in personal capacity as a researcher. I have been researching cybersecurity for more than 30 years, and all I know regarding AI and data protection comes from this particular view. So forgive me if I say something quite wrong, but my perception is that considering AI connected to data protection is something like a tip of the iceberg. We are looking at the consequences of misuse of data that could harm people. But as Professor Alberto said, we have a lot of applications that don't even bother regarding the individuals and the citizens and so on. So we have logistics, we have chemistry, we have nuclear research, we have lots of research that never touches the personal data. So when we talk about data protection at large, it would be nice to have a DPA regarding controlling it. But when we think about personal data protection, it sounds to me like a huge mistake to use a personal data protection agency to control a tool that touches almost every point of society, including my point, cybersecurity. So I was thinking that it was jabuticaba, as Philippe said, a very Brazilian thing to put together DPA and AI, but as far as I understand right now, it is something quite usual or unusual regarding many countries, including Chile. But I would like to know if someone sees a different perspective, a different possibility for Brazil right now, since we don't have my proposed cybersecurity agency that would be interested in a small part of AI also. But we also have some sectoral regulators that are quite limited in their scope. So what do you think would be possible for Brazil right now? Or should we do as the Americans have decided, let's not talk about AI regulation for a few years. Let's see what happens worldwide, and so see what we can do after that. Thank you very much for your attention.
Thank you for that question. Maybe let's go first already to a representative of a data protection authority.
I think you're right when you say that AI isn't all about the personal data. I think you have a point, and probably that's why we need a new law. But I also think that this kind of thought doesn't resolve the problems, because that's just how things are. We have a strong connection between AI and data protection, because as I said, many AI systems that are high-risk AI systems use personal data or impact people. So we need to face this kind of high-risk AI systems, looking and using the language, to quote here my friend, use the language of data protection law. At the same time, it's true that we have different uses or different AI systems that just doesn't use personal data, and that's probably why, from my point of view, we need to regulate, and we need to give this one more step to deal with these new technologies. I think just as Pedro said here, we have a new technology, we have impact on people, and we have big areas of concern of how these systems will impact on society. So we need to regulate this. We need to face the problems and the questions that they bring to us. So one of the tools that we have is data protection law. It's not enough. We need a new, probably, I think, we need a new law to deal with this specific problems and the specific impacts. So I think these are complementary point of views. Yes, data protection law and a new law that bring new tools that we can, that may help us to deal with the risks and to prevent harm to people.
I completely agree with Pedro in the point that it's not that much relevant what is the nature of the authority that we will have in place. Here the point is where we are going to be sure that the law will be enforced and that it will be enforced in order to protect fundamental rights or to fulfill other public interest purposes. That's the issue, okay? I tend to believe the Data Protection Authority may have, the Personal Data Protection Authority may have a challenge because it needs to realize that there is a lot of work associated to non-personal data protection, artificial intelligence systems that may have to deal with if assumed the competence. But on the other hand, the day of tomorrow, you will have autonomous cars driving here in Rio, and you will have the automobile administration trying to regulate the personal data protection, trying to regulate the use of personal data. You probably will have the Consumer Protection Authority also trying to regulate the role of consumers and the protection of, it can become really mess. At the very least, we need to have certainty that we will have a coordinating authority or mechanism to ensure that we don't need to go through that messy process that ultimately will translate in lack of enforcement to protect people and an ability of governments to fulfill public needs.
Yeah, I think Barbara also mentioned the European Data Protection Boards, who said that they basically want to be a single point of contact. They do not necessarily want to rule them all. They want to make it clear that there is one point of contact. Sorry, Felipe.
So I'd just like to make a clarification before anything. When I was referring to the jabuticaba, I was referring to the rights-based approach as the jabuticaba and not the authority mechanism, the supervision and the enforcement. I think that there are two things we need to think about. I think we all agree that if it was possible, everybody would like to create a new agency from scratch. But that's the ideal world. We have to think with the real world, with the real problems. How hard it is for ANPD, and here we have a representative, to really work. How long is it taking to actually have the enough resources it needs to operate in the real world and make a difference? So we are facing the exact same problem with AI. So creating a new body from scratch might have the same problems. But if it were ANPD alone enforcing AI as the single competent authority, maybe that would be a problem, but there would be a lack of expertise there. But since it won't be the only authority that will take part in this ecosystem, maybe these other agents that will be engaging in this regulation can help ANPD carry out this task, especially when it goes beyond the data protection concerns, which it has already the expertise. But my final remark would be the following. Do we want to use the data protection reasoning to AI? Because when we look, you have mentioned, Barbara, that maybe we don't have the Brussels effect in Brazil, which I kind of would slightly disagree, but in terms of AI. But the point is, even though we might not have Brussels effect on AI, we have a data protection effect on AI. Our law is structured in a data protection basis. But there's something even trickier that goes before that. Our data protection law is pretty much based on our consumer code. So at the end of the day, do we want to make AI a consumer code-based AI? Are we looking for a product safety legislation, which is something that was the initial desire, aspiration from the European Union to build on a product safety approach? So that would be my final remark, to think about what we want as an AI legislation. We want to take advantage of data protection and also from consumer code, or do we want to make something different and making something new adapted to AI?
Yeah, the closing word is for
I
Barbara.
know that I'm over the time, but I remember this. Last week we had this judgment, which is case C757/2022, which ruled that the German Consumer Association could go and try to enforce the GDPR. So we're kind of going back again. So even though they have the GPA, the German consumer, it's a mess, but I would just wanted to put this bomb and leave.
Thank you. Yes, indeed. And then it always comes back to the matter of resources and so on. I still have loads of questions, and I saw there were still some other questions in the room, but I'm sorry, we have to close it off. We are still around. Ask us questions in a more informal manner in the coming days. Thank you very much for your attention, and let's hope we can continue this conversation. Thank you.